Okay, let's get into this. Picture it. A narrow, unsealed country road, sometime back in the early 90s. Bit dusty, quiet maybe.
Until it wasn't.
Right. Then this sudden, awful sound of a collision. But not just two cars. This was a horse and rider hitting a Volkswagen Kombi van.
Yeah, and in the middle of all that chaos, the injuries, one really simple question pops up, but it's, well, incredibly hard to answer who was on the wrong side of the road.
Because, as the judges later said, very starkly,
Mm-hmm.
they could not both be right. Someone had to be mistaken.
In that single moment, that impact, it didn't just cause terrible physical harm. It kicked off this massive legal journey, years and years winding through the Australian courts, right up to the very top.
Yeah, this case, Fox v. Percy. It became about more than just who caused the accident. It became about, well, how do courts even figure out the truth when what people say happened clashes directly with the physical evidence left behind?
Exactly. So our deep dive today, it's all about this specific case. We're going to follow it, step by step, from that local court trial up through the appeals, all the way to the High Court of Australia.
And the stakes were huge. Personally, you've got Mrs. Barbara Fox, the writer, seriously hurt, looking for justice, for compensation.
And on the other side, Mrs. Megan Percy, driving the van, defending herself, saying it wasn't her fault. Their stories were just completely opposite from the get-go. But the real drama, it quickly shifts to the evidence itself, those physical clues, and how different judges looked at them.
We're diving into the actual court judgments, the High Court decision, the NSW Court of Appeal 1. They're incredibly detailed. They lay everything out, all the evidence, the legal arguments, how the judges reason things through. It's like getting a backstage pass to the justice system trying to sort out this mess.
Mm-hmm. Our goal here is to walk you through this whole legal story, introduce you to the people involved, understand the procedural twists and turns, and see what it tells us about trying to find the truth when you're in a courtroom.
So let's go back. April 1992. That's when it happened.
Right, yeah, over 30 years ago now. So you've got Mrs. Barbara Fox. She's the one who later appeals, the appellant, experienced rider on a big half-draft horse.
But she'd had some drinks beforehand, mixed rum drinks. Later on, a blood alcohol test came back at .122. They estimated it was probably higher, maybe .178 or .179 at the actual time of the crash.
And riding just behind her, her companion, Mr. Christopher Murdoch, he was also on a large horse. They were heading uphill, going east, quite slowly, maybe 7 kilometers an hour.
Coming the other way, downhill, heading west, was Mrs. Megan Percy. She's the respondent later on, driving her VW Kombi.
And the road itself, narrow, about 7 meters wide, unsealed, gravel, and the collision spot was right near this almost blind left-hand turn for Mrs. Percy coming downhill.
The crash was sudden. Van rounds a corner, bang, impact. Pretty much head-on between the van and Mrs. Fox's horse.
It was violent. Both horses, both riders, forced backwards. Miss Fox's horse got tangled up in the van somehow, then broke free, but its injuries were fatal. It died there.
And Mrs. Fox was thrown off onto the road right in front of the van. Mrs. Percy hit the brakes, and the impact itself stopped the van pretty suddenly.
And here's the absolute core of it, the mystery that fuels everything for the next decade. Mrs. Fox and Mr. Murdoch. They were adamant. They said, clearly, we were on our correct side of the road, the left side heading east.
But Mrs. Percy, just as certain, she insisted she was on her correct side.
Yeah.
The left side heading west.
It's impossible, right? Like, they saw two different events. As the High Court pointed out later, no wiggle room. They could not both be right. One version, maybe both, had to be wrong.
So the immediate aftermath, chaos at the scene. Authorities start arriving. First up, ambulance attendants.
And they noticed something important, testified about it later. When they got there, the Kombi van, stationary now, was on Mrs. Percy's correct side of the road.
Then the police arrive. Constable Peter Volf, he later becomes Sergeant Volf. He's the investigating officer. He talks to everyone involved, Mrs. Fox, Mr. Murdoch, Mrs. Percy.
And Volf makes some really crucial observations, writes them down right there in his notebook. He notes the van's final spot on its correct side. But even more critically, he sees skid marks, 10 meters of them, right behind the van. He even paced them out. Stepped out, the judgment says.
10 meters.
Yeah.
And those marks were completely, entirely within this Percy's correct lane. Undeniable physical marks on the road surface.
Yeah, and that physical evidence, it led Constable Volf to a pretty immediate conclusion right there on the scene. He wrote in his notes that the marks suggested to him, and I'm quoting loosely here, that the van had basically always been on its correct side.
And based on that, he actually said to Mrs. Fox, right there, amidst everything, it looks like you were in the wrong.
Oof, tough thing to hear at that moment.
Yeah. The court documents also mention Volf noted other things about Ms. Fox, her clothes, that she was apparently abusive towards police, had tattoos, smelled of alcohol. Now, the judgment points out the police form required noting distinguishing features.
But the trial judge later wondered if maybe those notes showed some, I don't know, animosity from Volf towards Mrs. Fox. Like maybe it slightly colored how he saw things. It's a little side note, but it comes up.
And just to muddy the waters a bit more, another witness shows up soon after the crash. Miss Christine Jakowski.
Ah, yes, Miss Jaskowski. She later testified, and she was apparently quite adamant that when she arrived, the Kombi van was on its incorrect side of the road.
So even right there at the scene, you have conflicting stories about where the van ended up, at least from the civilians, though the officer and the AMBOs agreed on its final position.
Right. So scene cleared, reports filed, and then the waiting begins. A really long wait. The crash was April 92, the trial. Not until November 1999.
Wow. Over 7 years. That's a long time for memories to shift.
It is. The trial itself took place over 4 days in the district court down in Maruia, New South Wales. The judge was Heron DCJ QC. That means district court judge and Queen's Counsel, a senior barrister. And importantly, he was sitting alone, no jury.
And the legal teams. Ms. Fox had solicitors, but the appeal judgments don't actually name them for this first trial. Mrs. Percy, however, was represented by a pretty well-known firm, Spark Hillmore.
Right, and both sides would have had barristers arguing in court, but again, their specific names aren't mentioned in the appeal decisions for the trial phase.
So the trial itself, this was a first big showdown. You've got Mrs. Fox and Mr. Murdoch sticking to their story. We were on our correct side. Mr. Murdoch even tried to dispute Volf's skid marks, saying he saw something like sideway drift marks, but not skid marks.
Then Miss Percy holding her ground. I was on my correct side. You had Constable Volf testifying about those 10 meters of skid marks, backing it up with his notebook sketch from the day.
The ambulance officers confirmed the van's position on Mrs. Percy's side when they arrived.
And then Miss Jakowski with her conflicting account saying the van was on the wrong side. The judge, Heron DCJ QC, he had to sort through all of this, decide who seemed credible, who was reliable, and what did the physical evidence actually prove.
And there was expert evidence, too. Both sides hired traffic engineers. But here's a really crucial point about how the trial ran.
Yeah, this is important. Neither expert was actually called to the witness stand. No oral evidence, no cross-examination. Their written reports were just handed to the judge.
Mrs. Fox's expert was a Mr. John Tyndall. He wrote 2 reports. The first one, he wrote it before he even knew about Constable Volf's 10-meter skid mark evidence.
Right. So in that first report, Tyndall basically theorized Mrs. Percy must have been at fault, and maybe her van hit the horse on the wrong side and then, I don't know, rebounded or spun back onto its correct side.
Then he finds out about the skid marks, so he writes a second report. And in this one, he seems a bit skeptical about whether the marks were exactly where Volf said, maybe questioning if they were totally on Mrs. Percy's side. But he still tried to argue Mrs. Percy could be at fault. Maybe the impact happened right at the start of the skid or something.
It sounds like he was trying to make his theory fit the new evidence, maybe.
It seems that way from the appeal judgments. And Miss Percy, she had an expert too, but we don't know who or what the report said from the sources, because, like Tyndall, they weren't called to testify either.
So the judge, Heron DCJ QC, he's got all this conflicting testimony, these expert reports he's just read. How does he decide? This is where the trial judgment gets, well, really surprising and eventually the source of all the appeals.
Okay, so first, he accepted Constable Volf's evidence about the skid marks. He found, yes, those 10-meter skid marks existed, and yes, they were entirely on Miss Percy's correct side of the road. He also accepted the van ended up on Mrs. Percy's correct side.
Right. He dismissed Miss Jakowski's evidence about the van's final position, said she must be mistaken, and while he noted that potential animosity from Constable Volf, he still accepted Volf's key observation about the skid marks being there, on Percy's side.
But here's the massive twist. Even though he accepted the physical evidence those skid marks showed the van braking hard on its correct side, he ended up believing Mrs. Fox and Mr. Murdoch's story that Miss Percy was actually on the wrong side when the impact happened.
How did he square that?
It seems he put enormous weight on how credible Mrs. Fox and Mr. Murdoch appeared in the witness box. He seemed to find their testimony more convincing than Mrs. Percy's, despite the physical evidence pointing the other way.
Okay, but how did he explain the skid marks then? If the crash happened on the wrong side, how do you get 10 meters of skids starting and ending on the correct side?
Well, this is where he relied heavily on Mr. Tyndall's expert report, specifically the first report.
The one written before Tyndall knew about the skid marks.
Exactly. The judge basically adopted Tyndall's rebound theory from that first report to explain how the van could end up back on his correct side after an impact on the wrong side, even though that theory didn't account for the 10 meters of pre-impact braking on the correct side that the judge himself accepted had happened.
Wow, so he accepted the skid marks were real and on the correct side, but then used an expert theory that ignored them to find the impact happened on the wrong side anyway.
Pretty much.
Yeah.
He actually said, and I'm quoting the judgment here, "I come to the conclusion that despite the skid marks, that the accident occurred on the plaintiff's correct side of the road, and of course in that I do not accept the defendant herself that the accident had happened on her correct side of the road." And he explicitly points to Tyndall. I think that I would accept Mr. Tyndall, and I think that the probabilities are that the vehicle ended up on its correct side of the road for the reasons which Mr. Tyndall advances.
That sounds problematic. Relying on an expert opinion that didn't engage with the critical physical evidence you've just accepted as fact.
It definitely raised eyebrows. So, based on believing Fox and Murdoch over Percy, and using Tyndall's flawed first report to explain away the skid marks, the judge found Mrs. Percy negligent. He awarded Mrs. Fox substantial damages.
You can just imagine Mrs. Percy and her lawyers at Spark Helmore hearing that judgment. The key physical evidence supports their client. The judge even accepts that evidence, but still finds against them based on witness credibility and an expert report that didn't fit the accepted facts.
Absolutely. So, no surprise, Miss Megan Percy appealed.
Which takes us up the ladder to the Supreme Court of New South Wales Court of Appeal. That appeal was heard in April 2001.
The bench was 3 judges, Handley J.A., Beasley J.A., and Fitzgerald J.A., the J.M.E.'s judge of appeal. Spark Helmore was still acting for Mrs. Percy. Mrs. Fox would have had her own legal team fighting the appeal, barristers and solicitors, but again, the judgments don't name them specifically for this stage.
And the type of appeal is important here. It was a rehearing on the record, meaning the appeal judges don't call witnesses again. They don't hear fresh evidence. They look at everything. The trial judge looked at the transcripts of what people said, the exhibits, the photos, the reports, all of it. Their job is to decide if the trial judge got it right based on that material, but they do have to give respect, give weight to the fact the trial judge actually saw the witnesses give their evidence.
Okay, so what was Percy's argument on appeal?
Her team, led by Spark Helmore, basically argued the trial judge's conclusion was just fundamentally wrong. Their main weapon, those 10 meters of skid marks, wholly on Mrs. Percy's correct side. They argued this was objective, undeniable evidence, a fact that made Mrs. Fox's and Mr. Murdoch's story that Percy was on the wrong side simply impossible to believe.
And they must have attacked the judge's use of the expert report, too.
Oh, definitely. They pointed out the flaws. The first report ignored the skid marks entirely. The second report seemed to rely on assumptions the judge himself hadn't accepted, like questioning where the skid marks really were. And crucially, since Tyndall wasn't cross-examined, they argued the appeal court was just as capable of assessing his written report as the trial judge was.
Makes sense. What about Mrs. Fox's defense of the judgment?
Her team leaned heavily on the trial judge's advantage. They argued, look, the judge saw these people testify. He assessed their honesty, their reliability face to face. That's crucial, especially when you're trying to piece together a chaotic accident years later. They basically said the appeal court shouldn't just substitute its own view based on reading paper. It should defer to the judge who was actually there.
So how did the Court of Appeal judges rule?
The majority, that was Beasley J.A., with Handley J.A. agreeing with her, they sided with Miss Percy. They went straight to those 10 meters of skid marks.
The physical evidence.
Exactly. They noted the trial judge himself accepted they were there and accepted they were wholly on Mrs. Percy's correct side. The majority called this a fact incontrovertibly established by the evidence. That's a key legal phrase. It means the evidence for this fact is so strong, so objective, it just can't reasonably be disputed.
Like a scientific fact.
In a legal context, yeah. Something solid you can anchor the case to. And then they looked at Mr. Tyndall's reports. They agreed they were flawed. First one ignored the key fact. Second one made unproven assumptions, or assumptions that contradicted what the judge himself found about the skid marks location. And they agreed, since Tyndall never testified, they were in as good a position as the trial judge to evaluate his written words.
So the conclusion?
Pretty blunt. They said the testimony of Mrs. Fox and Mr. Murdoch, claiming Miss Percy was on the wrong side, simply could not be accepted. Why? Because it was fundamentally inconsistent with facts incontrovertibly established by the evidence, namely those skid marks. They explicitly said it just wasn't possible to make sense of the trial judge believing Murdoch when his story directly contradicted Sergeant Volf's contemporaneous notes about the skid marks.
So this is where that legal principle about appellate review really kicks in.
Absolutely. You know, normally appeal courts are very reluctant to overturn a trial judge's findings when they're based on who the judge believes. That's the Abelos principle, and DeVries is another key case here. The judge saw them, heard them, assessed their demeanor. That's a huge advantage.
But it's not absolute.
Exactly. That deference disappears if the judge's findings based on credibility are just totally at odds with objective, undeniable facts. The appeal court has to step in then. And the skid marks here were that undeniable fact.
So the Court of Appeal majority did what?
They allowed Miss Percy's appeal. They threw out the trial judge's decision in favor of Mrs. Fox, and they entered judgment for Mrs. Percy instead, effectively saying, based on the evidence, negligence by Mrs. Percy wasn't proven.
Wow, huge turnaround. But you said majority. Was there a dissent?
Yes, there was. Fitzgerald J.A. dissented.
What was his view?
He thought the trial judge's conclusion was actually open to him. He felt the majority hadn't given enough weight to the trial judge's advantage in seeing the witnesses. He also criticized Mrs. Percy's legal team, suggesting they were attacking assumptions in Tyndall's report on appeal more strongly than they had during the actual trial, which he thought was impermissible. Basically, he felt the trial judge had weighed everything up and reached a possible conclusion.
Interesting. But the majority won the day. Mrs. Fox's win was gone. Was that the end?
Not quite. Mrs. Fox decided to take it one step further. She applied for permission special leave to appeal to the very highest court in the land, the High Court of Australia.
And did she get it?
Yes, she did. Special leave was granted. The High Court doesn't hear every case, only those it sees as having major legal significance or where there's a question about how the law's been applied. And this case clearly raised fundamental questions about appeal courts reviewing facts.
So the final showdown. High Court of Australia. Heard and decided in April 2003.
Right. The case was heard by the full bench, 7 judges. The judgments we have detail the reasoning of 5 key justices: Chief Justice Gleeson, Justice Gummow, Justice Kirby, Justice McHugh, and Justice Callanan.
And Ms. Fox's argument there? Still defending the trial judge.
Essentially, yes. Her team argued the Court of Appeal majority got it wrong by overturning the trial judge's findings, especially those findings rooted in his assessment of witness credibility. They were pushing back against the idea that the skid marks automatically trumped the judge's view of the witnesses.
And Ms. Percy's side, still Spark Helmore representing her.
Yes, Spark Helmore was there for Ms. Percy. They argued the Court of Appeal got it exactly right. The trial judge's findings, they said, were fundamentally flawed because they just couldn't be reconciled with that incontrovertible physical evidence, those 10 meters of skid marks, and were propped up by a misuse of the expert evidence.
Did Ms. Fox ask for anything else?
She did float the idea of a retrial if her main appeal failed, maybe arguing the trial judge's reasons weren't clear enough, but the High Court kind of shot that down quickly, saying it wouldn't make sense given how much time had passed and the nature of the evidence. You couldn't really improve on what they already had.
So the big question for the High Court was really about the power of appeal courts versus trial judges on factual findings.
Precisely. When can an appeal court step in and say, sorry, trial judge, you saw the witnesses, but your finding of fact is wrong because it clashes with the objective evidence? This case became the vehicle for the High Court to really clarify those rules.
And their decision?
Unanimous. Every single High Court judge agreed. They dismissed Ms. Fox's appeal. They upheld the decision of the Court of Appeal majority.
Wow. Unanimous. What was the core reason?
It all came back, again, to those 10 meters of skid marks.
The physical evidence?
The inescapable physical evidence. The trial judge himself had accepted they existed and were wholly on Mrs. Percy's correct side. The High Court unanimously agreed. This was an incontrovertibly established fact, an incontestable fact.
Yeah, because of that.
Because of that, Mrs. Fox's and Mr. Murdoch's version of events that Mrs. Percy was on the wrong side couldn't be right. The objective physical evidence was fundamentally inconsistent with their story.
And the expert evidence issue.
The High Court agreed with the Court of Appeal on that too. The trial judge's reliance on Mr. Tyndall's reports, especially the first one, to try and make Mrs. Fox's story fit the skid marks, that was flawed reasoning. The reports were based on incomplete info or assumptions that didn't match the accepted facts. And again, since Tyndall wasn't cross-examined, the appeal courts were perfectly entitled to assess his written reports themselves.
So the High Court confirmed the limits of deference to trial judges.
Exactly. They strongly reaffirmed the principle. Yes, you give great respect to the trial judge's unique advantage in assessing credibility, Abelos de Vries. That's vital. But it's not absolute. It doesn't shield findings from scrutiny.
An appeal court must intervene
If the trial judge's findings are clearly inconsistent with incontrovertible facts, or if they are glaringly improbable, or contrary to compelling inferences drawn from the objective evidence, those 10 meters of skid marks, wholly on Mrs. Percy's side, put the trial judge's finding about the point of impact squarely into that category. It just couldn't stand against the physical reality.
Did all the judges phrase exactly the same way?
Minor variations. Some focused more strictly on incontrovertible facts, others used broader terms like plainly wrong or glaringly improbable, but the underlying agreement was total. In this case, the physical evidence was decisive, and the trial judge's finding couldn't be sustained.
They acknowledged the limits of appeal courts reading transcripts, but
They also affirmed the crucial role of appeal courts in correcting errors, ensuring judgments align with the established facts, especially when objective evidence is disregarded or misinterpreted.
so the final word from the High Court.
Appeal dismissed. The Court of Appeal's judgment in favor of Mrs. Percy stood. The legal battle was over, more than 11 years after that crash on the country road.
Okay, let's just quickly run through that whole procedural maze again. It's quite a journey.
Okay. April 1992. The collision happens. Fox, Ryder versus Percy, van. Both claim they were on the correct side. Scene. Constable Volf notes 10-meter skid marks on Percy's correct side, makes a sketch. Ambos agree on Van's final position. Mrs. Jakowski disagrees on final position.
Before trial, Fox sues Percy in the NSW District Court. Percy hires solicitor Spark Helmore. Fox has unnamed solicitors. Both get traffic experts. Tyndall for Fox. Written reports exchanged.
November 1999. Trial. Murray District Court. Heron DCJ QC presides. No jury. 4 days. Witnesses testify. Fox, Murdoch, Percy, Volf, Ambos, Jakowski. Crucially, expert reports are tendered, but the experts don't give oral evidence or face cross-examination. Barristers argue for both sides, unnamed in appeal docs.
Post-trial, Judge Heron delivers judgment, accepts the physical evidence, 10-meter skid marks on Percy's side, van ends up on Percy's side. But based on witness credibility, he accepts Fox Murdoch's story that the impact was on Percy's incorrect side, relies on Tyndall's first, flawed report, pre-skid mark knowledge, to explain this contradiction, finds Percy negligent, awards damages to Fox.
Post-judgment, Percy, via Spark Helmore, appeals to the NSW Court of Appeal. Fox's legal team, solicitors, barristers unnamed, defends the win.
April 2001. Spark Helmore hammers the incontrovertible skid marks and the flawed expert report reliance. Fox's team stresses deference to the trial judge's credibility findings.
Post-appeal hearing, Court of Appeal judgment. Majority, Beasley, Handley, agrees with Percy. Says trial judge erred by accepting testimony inconsistent with incontrovertible skid marks and relying on flawed expert reasoning. Allows appeal, sets aside trial judgment, enters judgment for Percy. Fitzgerald J.A. dissents, backing the trial judge.
Post-Court of Appeal. Fox seeks special leave to appeal to the High Court. It's granted. Spark Helmore continues for Percy.
Heard, decision April 2003, High Court hearing. Justices Gleeson, Gummo, Kirby, McHugh, Callanan, among others. Big focus on principles of appellate review. Credibility versus objective evidence. Legal teams argue, Spark Helmore known for Percy.
Post-High Court hearing. High Court judgment. Unanimous dismissal of Fox's appeal. They confirm the skid marks were an incontrovertible fact overriding the trial judge's findings. They clarify appellate review principles. Intervention needed when findings clash with such facts.
And that's it. Litigation concludes. The final decision favors Mrs. Percy, all because of that physical evidence.
So really, when you boil it all down, Foxy Percy, after all those years, all those courts, it wasn't decided by who the judge liked more or who seemed more convincing in the witness box.
No. It turned on the cold, hard, physical evidence left printed on that dusty country road, those 10 meters of skid marks.
It's such a stark example, isn't it? This tension that's always there in the legal system. You've got the trial judge who's there watching people, hearing their tone, judging if they're telling the truth. That's incredibly important.
Absolutely vital. But then you have the appeal courts looking over their shoulder, making sure the final decision actually lines up with reality, with the objective facts that can't be argued away. They have a duty to step in when a finding just seems impossible based on the physical evidence, no matter how believable a witness might have seemed.
And you can't forget the human story behind the legal principles. Mrs. Fox's serious injuries, the trauma, how memory can play tricks, waiting 7 years just for the first trial.
And then the emotional whiplash. Winning in the first instance, thinking you have justice, only to have it overturned, appealed again, and finally losing definitively at the highest level. It's brutal.
It really makes you think, doesn't it? In our own lives, when we hear conflicting stories, who was really at fault? What actually happened? How should we weigh things up? How much stock do we put in someone's passionate personal account versus, say, documented proof or physical evidence?
Yeah, can someone's sincere belief ever truly overcome facts that just stare you in the face?
It leaves you wondering, in this world full of competing stories and different perspectives, where do you find your reliable skid marks? What are those objective anchors you can hold on to when narratives clash?